question is?
Mr. Speaker.
I call the honourable member Raymond Ho.
Thank you, Mr. Speaker.
Ni hao ma.
Kia ora. Well, that's a very nice comment from you. And anyway, on the third reading of this important bill and all the bills, I'd like to acknowledge the great work done by the Honourable Rick Barker, and also thank Ministers Tu Huhu and Simon Power for continuing the great initiatives. Work on this bill commenced in 2004 through a review of the infringement system undertaken by the Ministry of Justice and the Law Commission. A joint discussion paper entitled Options for Reform, the Infringement Review Discussion Document, was issued in November 2004. Initial reforms were made by Cabinet in March 2008, approving guidelines for new infringement schemes developed by the Ministry of Justice. I outlined the background to show that there is a gap between then and now, and I acknowledge Dr. Kennedy Graham, who also commented in a similar fashion in his speech as well. The bill was practically ready when Labour left government, and I'm wondering, echoing the concerns expressed by my colleague Lim Pillay earlier, that why it has taken so long for this bill to come before the House. The bill is far more important and urgent than a number of other pieces of legislation rammed through by the national government through urgency sessions. This is urgent matter, Mr. Speaker. Figures released earlier this year showed that between July 2008 and June 2009, courts had wiped $95.1 million of the total $806 million in unpaid fines. The amount of outstanding fines is increasing each year, and it is a problem that needs to be addressed. The amendments to this Act will address concerns about the amount of overdue fines, the dissatisfaction of victims when offenders do not comply with reparation orders, and the frustration of creditors and debtors using the court's civil debt enforcement process. The bill is an omnibus bill and has divided and was divided into 20 bills at the Committee of the Whole House stage. Acts with substantial amendments include District Court Amendment Bill, Land Transport Amendment Bill, and a Summary Proceedings Amendment Bill number 3. My colleagues have spoken rather substantially on those bills, and I only reiterate some important points at this stage. The first one is with regard to the attachment order. Attachment orders are used to allow deductions to be made from wages and benefits to pay debts. At present, attachment orders can be imposed only after an examination hearing to assess the judgment debtor's ability to pay the debt. Both parties are required to attend the hearing, which can be inconvenient and incur delays and costs. This bill aims to streamline this enforcement process by enabling judgment creditors to file a financial statement or ask the court to assess the debtor's financial means in the debtor's absence. But judgment creditors would still be able to apply for a formal examination hearing, of course, which both parties would have to attend. It is believed that this will avoid delays, costs, and inconvenience for all parties concerned. At the Law and Order Select Committee, we received 16 submissions from individuals, organizations, and other parties. Some submitters commented that the removal of the requirement for a hearing personally attended by the creditor and the debtor is a favourite change because of the money and the time spent attending those hearings. Other concerns included that an individual may be subject to enforcement action without being aware of this as a result of the removal of these requirements. Some submitters also expressed their concerns about relying on the presumption of service and this weakening and the weakening of the current service provisions. Mr. Speaker, I'd like to note Money Shop Group Limited and its submission. Money Shop Group Limited is concerned about the lower priority given to civil debts that are being resolved by attachment order when government debts, such as fines, for example, are also being collected by attachment orders. They consider that priority should be based on time of action, as is the case for all civil debts, rather than the priority order being set in legislation. I agree, however, to the advice given by the officials. Priority for enforcement deductions from wages and benefits is driven by the interaction of various statutes, including the Child Support Act, the District Courts Act, the Summary Proceedings Act, and so on and so forth. It reflects the general principle that public debt takes priority over private debt. Any change to this principle and the interactions between these pieces of legislation is beyond the scope of this bill. Regarding the Summary Proceedings Amendment Bill number 3, some substantial amendments being made included credit reporting, super priority, and registrar's powers if a fine unpaid or if time payment arrangement or attachment order cancelled. I noted the submission from the Privacy Commissioner. The Privacy Commissioner is particularly concerned about the release of government-held personal information to private sector credit reporters and the shift in the use of personal information that this signifies. The Commissioner recommends that Clause 69, which sets out the credit reporting initiative, be removed from the bill. Mr. Speaker, I also want to acknowledge a submission by Veda Advantage regarding Section 92D, in that it submitted that the bill should allow for online or telephone communications. I further note recommendations from other officials that subsection 92D, sub D, sub I in clause 69 be amended to provide a technology-neutral method of recording agreement in order to allow consent to be expressed in multiple ways, for example, written, electronically, or verbally. We're living in a modern world, there's no doubt about that. However, I have 3 further concerns. The first one is there are more than 80 issuing authorities and obviously will impede the collection of fines. To remedy the situation, Labour suggested that a single agency be established to take responsibility for fines. My colleagues and I raised this matter in our previous contributions and in particular at the committee stage, but it appears that no action has been taken whatsoever, so the proposal has been omitted, and it is very regrettable. And secondly, with regard to the so-called 3 strikes, and I note Minister Tahuhu intended to introduce an SOP at committee stage that will allow offenders convicted of a 3 strikes offence but not warned of the consequences of a further offending to be brought back before the court to have the warning issued at a later date. I did not have the opportunity to take a further call at the committee stage. I would like to hear from the Minister with regard to the rationale and related matters. And the third one is with the less trepidation is that the regulatory impact statement duly pointed out that the credit reporting component of this bill is inconsistent with the Privacy Act 1993 and the Credit Reporting Privacy Code 2004. The bill overrides overrules the Privacy Act, but the Ministry of Justice will conduct a review after 2 years of the credit reporting scheme to determine whether the outcomes justify the impact on privacy. With those notes, I commend the bill to the House.
Mr. Speaker.
I call the